Tormsdale wind farm, the development of 9 wind turbines with a ground to blade tip height of 149.9 metres and associated infrastructure, including a battery energy storage system, and to report to them, to ministers, with my recommendation as to whether Electricity Act consent and deemed planning permission should be granted. The purpose of today's meeting, as I'm sure you all know, is not to discuss the merits of the case. That'll happen during the inquiry itself. It's merely to discuss and hopefully finalise the arrangements for the inquiry that will take place at a later date. Before I forget, I need to remind you that we're recording and live streaming the event to our YouTube channel. So if anyone's not content to be part of that, you need to leave the meeting now. And of course, you're welcome to follow it on the YouTube channel without becoming part of it. If anyone's not used to using Microsoft Teams, if you want to attract my attention, you can raise your electronic hand as an alternative to your real hand. I'll spot the electronic one better, I suspect, which you can deploy by using the raise button at the top of the screen. And if I haven't spotted you, you're very welcome to butt in and tell me so. But I will try and keep track of who wants to speak and the order in which people made those requests. So before we kick off, I'll explain obviously what we're going to be doing. But before we do that, I think I'd like to ask those who represent the various parties at the meeting to introduce themselves. So at this point in the agenda, if you're not sure whether you want to speak, you're perfectly welcome not to introduce yourself now, and you can simply do that later on. But I know certain parties will have a great deal to say, so I'll be asking specific people or specific groups of people if their representative could introduce themselves now. And I'll start, please, with who represents the applicant.
Thank you, sir. Good morning. My name is Marcus Trinick. I'm a solicitor of King's Counsel, instructed by Fraser Gillis, whose face is on the screen, and I'm accompanied on screen by Alexis Teisler, who is the project manager. Thank you, sir.
Thank you. Morning, Mr. Trinick. And who appears for the council, Hallam Council?
Morning, sir. I do. My name's James Finley, King's Counsel. I'm instructed by Rhoda Banfro, who appears on screen, and Michael Cordus, I think, is still trying to join us, but there's no need to delay anything until he does.
Okay, thank you, Mr. Finley. And who appears for Holkirk and District Community Council, please?
Good morning, sir. Ian Kelly, independent planning consultant. I appear for a group this morning. I appear for Holkirk and District Community Council, for Ms. Catherine Haltoner, and also for various locally resident third parties. I'm hopeful this morning, sir, that I can handle all the contributions myself to make things simpler. And as some people already know, I have postponed going on holiday to take part in this meeting. So 12 o'clock is my cut-off time, sir. I have to leave at 12 o'clock for a train, but hopefully, based on discussions that have taken place, things should go smoothly. I should say, sir, that to help with procedure, once I respond to the minute of the pre-examination meeting, I will give you a definitive list of the people I represent. Thank you.
Okay, thank you, Mr. Kelly. I had heard you'd kindly postponed your departure. I'm grateful for that. In terms of when I issued the note of this meeting, that will be next week, and it will give a deadline of 14 days to respond. You'll be back before then, I assume?
Yes, sir. I'm only away for a week, and there's a little case called Carnade Hub that is going to disturb me during this week. Anyway, yes. So I'll be back a week today, sir.
Okay, thanks, Mr. Kelly. Okay, who appears for Nature Scott today, please?
Good morning, sir. My name's Callum G. I'm a solicitor and partner in the firm of Solicitors Harper McLeod. I am instructed on behalf of Nature Scott, and I'm joined today by Sophia Irvin, who's a renewable energy casework advisor, and Jennifer Heatley, who is an energy casework manager, both of Nature Scott.
Excellent. Thank you, Mr. Chair. And for the RSPB, please.
Hi, I'm Esme Cleland. I'm Head of Planning and Development with RSPB Scotland, and I'm here with my colleague Bea Ailing, who's the Conservation Officer for the area.
Excellent. Thank you, Ms. Cleland. And for Caithness and District Salmon Fishery Board?
Good morning. My name is Alan Jensen, and I'm the Science Consultant for Caithness District Salmon Fishery Board.
Thank you, Mr. Youngson. Is there anyone else who definitely intends to address us? No? Okay, that's great. So, as I say, if you haven't introduced yourself, but something dawns on you that you want to say, that's absolutely fine. And you can just tell us who you are when you contribute. I'm aware there's parties who weren't able to make this meeting. That's absolutely fine. They'll still be able to opt into whatever further procedure we're going to have. As I said to Mr. Kelly, I'll be issuing a note of this meeting next week, and there'll be 14 days from whenever that note goes out for parties to decide if they want to take part in whatever further procedure we're going to have. And obviously, as I said, the meeting will be on our YouTube channel, so anyone who wasn't able to participate will be able to view that at their leisure. So moving on to item 3 of the agenda, which I'll try and cover quite briefly, but it's really for the benefit of those who are less familiar with the inquiry process. The Code of Practice for Handling Inquiries under Section 62 and Schedule 8 of the Electricity Act. Effectively, what the Act says is when planning authorities objected to a Section 36 application, as is the case here, a public inquiry must be held. And well, the law's actually changed on that recently, but it doesn't apply to this case. The Code of Practice confirms that a public inquiry doesn't necessarily have to be what you might imagine that involves, which is witnesses being cross-examined by lawyers, although sometimes that is actually the best approach. It confirms that it may be possible to consider the matters in dispute in a less formal way that's more efficient in terms of cost and time, etc. And it establishes that the point of the pre-examination meeting, which we're having today, is to hopefully get agreement as to what would be the best method for me to employ so that I can get the information I need to report to ministers with a recommendation as to whether the scheme should go ahead. And item 5 of the agenda is where we'll come to that and discuss what we think will be the best combination of procedures to get to the bottom of all of that. Before we get too far down that road, I'll just explain for the benefit, as I say, of those who are less familiar with the process, what the different options we have are. The first is for me to rely on the existing written material, which is quite extensive. Obviously, the application's been in for a long time. There's been various rounds of changes to the scheme and various comments upon those changes. So I have quite a lot of existing written material I can rely on, and it may be for some topics that that's perfectly adequate. The second option I have is to seek further written submissions. So if I have any remaining questions or uncertainties, I might think the best way to get to the bottom of that is by seeking further comments from those parties who've raised whichever issue it is. There are then 2 options if I think that wouldn't suffice, which are to hear submissions orally, either in person or in a format such as this, a virtual format. So they are a hearing session, which is a relatively informal roundtable discussion about the topic in question. There's no cross-examination by lawyers, etc., although lawyers are very welcome to participate in the discussion. It's a discussion led by me, where I'll ask a series of questions to try and get to the bottom of any areas of uncertainty that I have. And it's a chance also through me for parties to ask questions of each other if they think I haven't got to the bottom of something they think is important. And what I'll usually do with a hearing session is issue a draft agenda many weeks in advance so that people have a chance to think about whether I've covered all the ground they think is important, and they can add questions to that agenda that they think I do need to cover. So that's one option. The other more formal option is what's called an inquiry session, which is what people might imagine when they think of a public inquiry, which is witnesses giving evidence at a witness table and being cross-examined, etc. Sometimes that's very useful to the reporter because it enables experts to be grilled on their technical evidence, and sometimes it's essential to get to the very bottom of something where there's a profound difference of professional opinion on highly technical matters. So that's another option. And the final form of procedure that we are quite keen on is a community hearing session. So that is a far less formal, although not entirely informal, session, usually held in the evening. And the idea is that members of the community can raise any matter that they've raised previously that's of concern to them. So it doesn't necessarily have to be pigeonholed into one of the other categories that we were going to talk about. It can cover any element that they're concerned about. And the administrative procedure for that is a lot less onerous than it is for some of the other forms of procedure. So you don't need to submit things weeks in advance, etc. Although we do ask usually a week or so before a community hearing session that parties who want to take part in that do tell us in writing what they're going to say on the night. That's in the interests of transparency and fairness. But apart from that formality, it's relatively informal. It's a chance for people to tell me at a time and place that's convenient for them, hopefully, what they think about the proposal, so I can incorporate that into my report to ministers. So I don't want to give the impression that members of the community have to go down that route only. You're welcome to participate in the community hearing session if you think that's useful. You're also very welcome to participate in any more formal session or topic-specific session if we are to have some. It's just a matter to bear in mind when you're thinking about what sort of involvement you might have in the process. I would say the more formal sessions, if we are to have them, are a bit more onerous in terms of submitting evidence by deadlines, and we're very strict on that, and exchanging your submissions with other parties. So there's a bit more administration involved in that. But as I say, I wouldn't want to put anyone off from participating in any session that they're interested in getting involved with. So I suppose the other matter I would say is obviously I will need to visit the site and the surrounding area. Generally, reporters do that on an unaccompanied basis in advance, so sometime between now and whenever the inquiry takes place. But we are also very happy to take part in an accompanied site visit if there are particular things that parties wish us to look at. Quite often it's views from residential properties and things like that, which we couldn't easily do on an unaccompanied basis. So no need to discuss it today, but going forward, if there is a desire for me to look at something in particular, then that can be programmed into the inquiry process, and we'll try and achieve that. So if we're having oral process sessions in the area, then during that inquiry week, we'd find a time to go to whichever sites we think or people think I need to visit on an accompanied basis. Right. Sorry for whittling on so long. We can get to the more interesting part of the agenda, starting with item 4, possible need for additional information. So as I said, I need to write a recommendation to ministers as to whether the proposal should go ahead. To do that, I need to, for all the matters that are in dispute, I need to decide which side of the argument I prefer. And to do that, I need to make sure I have sufficient information. And under item 4 of the agenda, I want to consider what evidence, if any, might be missing or might require updating. It's a separate discussion to what we'll talk about in item 5, which is the format for discussing the evidence. Item 4, I just want us to focus really on what information might be missing that would prevent us having a subsequent useful discussion, either orally or in writing, on the matters that are in dispute. I set out a few matters in item 4. They're not necessarily matters where I've decided evidence is missing, let alone matters that I think constitute additional information under the EIA regs and therefore require certain procedure to be gone through in terms of publicity, etc. I merely looked through the case, saw that submissions had been made that indicated that certain parties think that certain additional information might be necessary. And I really wanted to just see what the parties think so I can come to a view as to whether, first, we do need more information or evidence, and second, whether that would trigger any requirement, any procedural requirements in terms of publicity, etc. And if so, then we can kick that off now rather than it compromising or possibly delaying the progress of the inquiry later on. Identified, I think, 4 issues in the agenda that might be worth talking about. It maybe you think there are others, and I'm happy to hear of those. But the 4 identified are implications of the recent Rayshore Farms judgment, possible need for updated cumulative effects assessment, possible need for additional ornithology evidence that RSPB had highlighted, I believe, and whether the evidence on effects on salmon is sufficient for me to come to a view on those issues. So I'd like to go through all of those in turn, and then we'll come to whether there might be any other issues that information is insufficient for. So Rayshore Farms was the first one. As you know, I'm sure, many of you anyway, the in-house found that, among other things, the decision maker needs to turn their mind to the question of what constitutes the project in EIA regulations terms. I'm particularly interested in whether the parties think that the environmental effects of the grid connection that will be required for this wind farm ought to be considered as part of the project for EIA terms, and therefore how much information I require to have at this stage before me. I know Mr. Finlay and Mr. Kelly in particular will have a view on this. I know also the RSPB and the Community Council also raised the question about the effects of the grid connection in their submissions. So I'm sure people have a lot to say about it, but in the interest of maybe shortcutting the process, I thought I'd ask the applicant first for its position. Mr. Trinick, if you could go first and let me know what you think about Rachel. Thank you.
Thank you, sir. Yes, I have been giving thought to the judgment. I think you will need to receive written submissions on what the judgment means so far as this case is concerned. But at a practical level, I can indicate that the applicant's response will be to provide environmental information on the cumulative effect of the generation plant, the wind farm, with the grid, based on a route to the grid connection point, and that point is known, which seems most likely. That will involve providing additional information in terms of the statutory environmental impact regulations. We can have that information ready by late June. And I asked for a Regulation 20 direction that you ask for the information for the purposes of the inquiry. So I'm not going to say what I think of the Rachel Farms judgment now. It will come later, but that's our response to it.
Thank you, Mr. Trinick. That's very helpful. Yes, I think if that's the way we're going, then I would propose to incorporate into my note of the meeting next week a Regulation 20 request for you to do that. First, can I hear, Mr. Finlay, do you have any disagreement with that approach?
No, none. It seems entirely sensible, and frankly, if that's the approach that's been taken, and we understand that the grid connection is going to be undergrounded, whether you need written submissions is a matter for you, but we'd be content in this case, given what Mr. Trinick has indicated to me, that there's no need for further written submissions, given that the AI is going to cover the grid connection. And there's plenty of time to deal with that prior to the likely inquiry date. So in complete agreement.
Thank you, Mr. Finlay. Sorry, Mr. Trinick, I didn't clarify. Is that right? As you understand it, the likely grid connection is to be underground. Is that correct?
Underground and along public roads entirely.
Okay, that's fine. Okay, so yeah, that's helpful to know. Okay, so Mr. Kelly, I'm assuming you don't disagree with any of that?
I don't disagree with any of that. I'm sort of perfectly happy.
Excellent. Anybody else had any comments on the racial judgment? No. Excellent. Okay, thanks. So as I say, I will incorporate within the note of this meeting a request to the applicant to provide that under Regulation 20 of the EIA regs. As I say, upon receipt of that in June, late June, obviously I'll consider what it comes up with at that stage. If I think further written submissions would be required, then we can do that, and there'll be plenty of time to incorporate that within the process without compromising any subsequent procedure that we might have. So it's very helpful. So the second item on my list of possible gaps in the information was on the assessment of cumulative effects. And I think the last assessment was March 2025 in FEI2 from the applicant. It's really, that's not particularly long ago, but I know things are constantly changing. Mr. Trinick, do you think there's a need for any updating since then?
Yes, sir. That will be provided by the 29th of May. And we're going to use, unless anybody thinks otherwise or wants otherwise, a cut-off date for the baseline information of today, 13th of March.
Anybody have a problem?
Okay, again, sir, I asked for a Regulation 20 direction for that information.
Indeed. Anyone have any problem with having today as the cutoff? No. Nope. Excellent. That's good. Thank you. Okay, so item 3, and again, I say I don't know, or I haven't come to a view one way or the other, but I did notice that there was, in RSPB's comments, there was some reference to possible gaps in the evidence. Before I come to you, Ms. Klein, Mr. Youngson, I know you've got your hand up. Do you want to say something now?
Yeah, just to drop back to your item 2.
Yes.
I don't know if it's relevant, but you perhaps are aware already, but if not, you should be aware there is a proposal in to repower Cassie Meyer, the original Cassie Meyer wind farm, which is adjacent to the Tormsdale site and also abuts on the SEC. So I imagine at some point it will be necessary for one or both parties to do a cumulative assessment. But the repowering project only came in a month ago, perhaps 6 weeks ago. So it's you might wish to be aware of that.
Thank you, Mr. Johnson. That's helpful. You probably don't need to answer that, Mr. Trinick, now, but I'm sure you will take account of whatever stages these various projects are at in your assessment of what needs to be assessed. Yep, thank you. That was helpful. Thank you. So going back to ornithology and Ms. Cleland, I'll just I may be overstating or understating the importance you attach to these various bits of information, but the three things actually that jumped out at me from RSPB submissions that might indicate you think there isn't sufficient information, 2 of which I think I mentioned in the agenda, 1 of which I didn't because it dawned on me yesterday. First was the adequacy of cumulative collision risk monitoring. Second was the issue of white-tailed eagles and whether there are adequate flight activity surveys. And the third one was relating to in Harrier and potential for collision risk during courtship displays, displacement effects, and disturbance effects during construction. So 3 issues. As I say, it may be that you don't think there's an evidence deficiency, or it may be that you do. Just so I can get clarity on that before I ask what other people think, could I ask you, Ms. Cleland, what your views are on those 3 matters?
Yeah, certainly. We would certainly welcome the updated cumulative assessment. So assuming that would include an updated collision risk assessment, and we've also asked for updated disturbance and displacement assessments from that, assuming they would be included in an updated cumulative assessment. And in terms of the vantage point and collision risk assessment for white-tailed eagle, we would certainly welcome an update on that, because the baseline for that species has changed since the application was submitted and since the bird surveys were done in, I think it was 2019 and 2020, I understand. Additionally, we had also made comments in our letters in terms of common scoter, and there has been some additional information which has come up through other projects, notably the Spittal to Bewley overhead line, which had found recordings of common scoter. So we'd also welcome a kind of a reassessment if there was more, more information that had been come to light through other assessments, which might impact the assessment on common scoter. And lastly, in terms of the impacts on the Ramsar site, we're just mindful that the policy position had changed for the Scottish Government in terms of how impacts on the Ramsar sites should be assessed. And I suppose just to ensure that there was sufficient information on the species that weren't covered by either the SAC or the SPA. But that's kind of not our area of focus, but we just noted that there might be kind of gaps in that area.
Thank you. Yeah, I had that as a note to ask about the Ramsar site because it wasn't entirely clear whether you were maintaining an objection about potential impacts on the Ramsar or whether it was just a sort of question mark as to be honest, I haven't looked to see what the qualifying species differences are between that and the other designations to see if there's a gap or I think the answer that you just said was a question mark. Is there adequate coverage in order to, because obviously we have to apply the new policy. To Ramsar, right? So
certainly, in terms of bird species, my understanding is they're covered by the SPA designation, but there may be other plant and other species that may not be, but that's not the focus of our comment.
No, okay, thank you. That's helpful, Mr. Trinick. So there's a few matters that I don't know whether you were already planning to cover those in your updated cumulative assessment, or if there's anything in that list that you weren't and that you think you shouldn't. If you can let me know now.
Yeah, so based on our own consultants' views and based on the position of Nature Scott, we do not see the need for any further cumulative assessment, whether for collision risk modelling or displacement, for white-tailed eagles, nor for hen harrier, nor for common scoter. However, looking ahead, if I may, briefly to item 5 on your agenda, effects on birds, my suggestion is that to put you in a position to decide whether or not you need further process, that you invite further written submissions from, in the first instance, RSPB, so we know exactly what their position is. We can then respond to the further written submission. That will put you in a position to decide whether you need more information.
Okay, yeah. Sounds quite.
I've also noticed that just to reassure Esme Cleland that I've noted the RSVB letter. They don't wish to take part in an inquiry process, but they're happy with written submissions. I agree.
Okay.
Although it's for you to decide on process.
Indeed. So, Ms. Cleland, does that sound like a plan that I write to you in terms of what I understand to be your current position on not just on the adequacy of the evidence, but also based on what evidence we do have, what you think the effects would be on the various additional species beyond, I think it was just short-eared owl that Nature Scott's objection relates to. We'll come to that in a minute. But I write to you, seek further written submissions, so you can sort of consolidate your concerns, and then the applicant can respond to those. So we'll do it in writing. I mean, I'll have to say I'll reserve my right to, if I really think I need to, I always have the right to insist on some sort of oral process. I'm not in the habit of trying to force people to come to an inquiry because I appreciate the restrictions everyone's under. But so hopefully we can get to the bottom of it in how far apart you are on these issues in writing. But does that sound like a suitable plan that Mr. Trinick suggested? Yes.
Yeah, absolutely. And yeah, we appreciate there's a number of submissions, and so certainly consolidating everything is understandable. Yeah, that's fine.
Excellent. Okay, that's good. So,
sir, I'd put my electronic hand up there. There is some local interest in ornithological matters, although we don't have an expert witness. The principal issue in terms of local people is that their observations and have seen bird species that are not included in the assessment. I think the simplest way for us to deal with this, sir, is if you included myself and the Community Council in the written submission exchange, we would simply provide a list of species that are seen in the area, and then others can consider whether they need to give you more evidence on this, sir. It would simply be a factual listing rather than an assessment of any sort.
Yeah, happy to do that. That makes sense. Local people know what they see on the site. So yes, very happy to do that. Good. Nothing else on birds in terms of the evidence base? Nope. Okie dokes. So salmon was the other issue where, and again, Mr. Youngson, I might be misinterpreting what you've said. Appreciate you and the applicant are not in agreement on potential effects on salmon, but at this stage, I just want to consider whether we've got sufficient information for me to come to a conclusion on that. So in terms of the evidence base, am I right in thinking you think inadequate information has been gathered at this stage, or is it that you simply disagree with the conclusions that have been reached?
Both, actually.
Okay. So what do you say is missing in terms of the evidence base on salmon?
Well, we're still missing. I mean, I've expressed this very clearly, but we're still missing an effective assessment of direct visual effects and also shadow flicker. But especially the shadow flicker assessment is not adequate for technical reasons, which I won't bore you with. And the direct visual effects hasn't never been treated at all. So I should say, to help you, I realize that this is quite technical.
Indeed.
And I will, so I've sort of put myself at your disposal, really. I will supply any explanation or any information that's available on request. So I'm at your disposal, really. I realize there is a problem dealing with this.
Thank you. That's helpful. Mr. Trinick, do you agree that inadequate information has been put forward to enable me to make a decision on this issue or these issues?
Funny enough, no. We think that we produce more than adequate environmental information on the shadow effects. I do not use the word shadow flicker.
No.
Shadow effects on salmon, non-direct visual effects, and we're ready to proceed to an inquiry session, as we will discuss later.
Okay. Okay, thanks. Okay, I'm not dismissing your observation, Mr. Stevenson. I have Mr. Trinick's view on behalf of the applicant that he thinks sufficient information has been submitted. So we'll come in item 5 of the agenda to discuss how we will look at that evidence, and obviously it's the applicant's discretion to decide what they think is their best case and what's adequate in terms of the information, and I will then base my assessment on the basis of that information and your own evidence, and we'll talk about what's the best way to deal with that in item 5 of the agenda, which is coming up very shortly. So in terms of anything else in terms of the evidence base that we think needs to be addressed now, is there anything else anyone wants to raise? Mr. Kelly?
Yeah, yes, sir. My local clients have concerns about the impact of the proposed access route to the site. I have had email discussions with Mr. Trinick, and we have agreed that we suggest to you that you ask for written submissions on the physical effects of the access, allow for a short rebuttal, and then we are content to leave it with you, sir, as to where you feel you need any further evidence beyond that. But I would stress it's the physical effects of the construction and operation of the access route rather than the landscape and visual effects of that route. So we both feel that written submissions and a short rebuttal and then leaving it to you, sir, is the way forward.
Okay, thank you, Mr. Kelly. Is this access issues in the immediate vicinity of the site or on a more wide basis on the route?
Well, it's in the immediate vicinity of the site, sir, going past houses and through Westerdale through the site. So it's
okay.
the immediate access to the site rather than wider transportation issues.
Okay, thank you. Mr. Trinick?
Thank you, sir. Yes, Mr. Kelly is quite right about written submission on transport. Very happy with that. I put my hand up for something separate. I can't now seem to lower my hand. You're stuck with it, I'm afraid. On the question of short-eared owl, we are undertaking further survey work during the 2026 breeding season. We think that information will be helpful to you. Whether or not it's required is another matter, but it'll be helpful. And the results will be released to Nature Scott as soon as available, obviously, but will be available to the inquiry in published form by early August.
Okay. So in terms of
26th, if we think we're 26th October start date for the inquiry, we think that's in time.
Okay, good. In terms of whether I need to ask for that regulation 20, obviously I don't know what it's going to reveal, but if this is sort of substantive information about something that should be in the EIA, is it worth me asking for it just to be on the safe side? Depending on what it comes up, it could come up with some very significant problem information. Should I include that in my Reg 20, do you think?
Yes, I think that'd be sensible.
Oh.
Yeah.
Okay, thanks. Anybody else want to say anything about either the transport or the owls issue before we go on? No? Ms. Burns, yes.
Yeah, it was just to ask if it was possible we would RSPB Scotland would welcome seeing the information, the results from the 2026 short-eared owl survey as well as soon as possible, if the applicant is happy to do that.
I'm sure they will be. Yep, excellent. Thanks, Mr. Trinick. Good. Okay, so getting to what is often the the big part of the of a pre-examination meeting, which is agreeing how we will discuss, if we are indeed to discuss, the various topics that are in dispute. And I always preface this part of the agenda by saying, just because I haven't identified something as needing to be subject of oral process or even further written submissions doesn't mean it's unimportant. It may be I simply understand where the various parties are in that topic. So I don't think I need any more information in order to make my recommendation to ministers. But there are some items where I think I do need further discussion, or either in written form or orally. First being visual effects. It appears, if my understanding is correct, that from the council's perspective at least, we are talking visual rather than landscape effects. And although maybe not localized, they are probably, in terms of my ability to understand them, relatively limited. I'll ask Mr. Finlay first. Is that correct? And I'd suggested in the agenda that a hearing session could cope with that. Are you content with that, or you even think that further written submissions on the subject might be sufficient?
Well, we're content with the hearing session. I hadn't actually contemplated further written submissions, but I think Mr. Trinick and I agreed that a hearing session would probably be the most appropriate, and that will be as long as short as you wish to make it, in a sense. But yes.
Yeah, that's. I mean, I was leaning towards a hearing session just because there's always the risk I ask something in writing and then that brings another question, which I then have to ask in writing again. And quite often it's easier to sit around a table and say, tell me what the issues are, and that can prompt discussion that will get me to the point I need to be. Mr. Kelly, did you have any problems on behalf of the community on a hearing session?
Very happy with the hearing session, and the community would take part, represented by myself. So
excellent. Anybody else on landscape, or should I say visual effects, to be discussed in a hearing session? No. Excellent. So the next matter in terms of the procedure, coming back to you, Mr. Youngson, with effects on salmon. And I hear what you say about the adequacy of the evidence base, and we hear what Mr. Trinick says about that they are content, they've gone enough. So, as you say, it's a very technical matter. I won't pretend to understand what I need to do based on what I've seen already. So my inkling, and I think it was Mr. Trinick as well, that this would require to be a formal inquiry session where you as the expert and the applicant's expert can give evidence before me and be subject to cross-examination. Are you content that that would be the best way to get to the bottom of this?
I think there's one other matter you need to feed into that.
Yes.
And the board is sort of in dispute regarding, as you mentioned before, regarding the information that's been supplied and the conclusions that were drawn from it. But there's also another party involved here, and that's NatureScot.
Yes.
And I think NatureScot would have to feed in there as well, and in order to tell us what they really think. The reason I say that is because their position appeared to develop between 2024 and 2025 for reasons that I can't understand. I don't think there's any formal way for me to, I have been in touch with NatureScot, but I don't think there's any way for me to respond formally to their document because they have the last word. But I think for your benefit, you need to be aware of potential problems there.
Yeah, I'll come to Mr. G, because my understanding was that NatureScot's ultimate position was that they might be content subject to conditions in terms of the effects on salmon. I'll come to Mr. G. Is that the correct understanding? And whether or not that's correct or not, was it your intention to participate in an inquiry session in regard to salmon?
Yes, sir. Your understanding is correct. NatureScot are content that their objections in relation to salmon can be dealt with by condition, and they were not, as matters stand, although they will of course assist you in whatever way they can, intending to participate in any oral process in relation to the effect on salmon.
Okay, thank you. That's helpful. So, Mr. Youngson, it would be yourselves and the applicant's expert.
In that case, we would probably decline cross-examination because all the witnesses wouldn't be there.
The witnesses wouldn't be what,
We're
sir?
happy to have an informal conversation, but we couldn't go to that level of formality without the presence of Nature Scott.
Okay, okay. Is that because you wouldn't have your own advocate to speak for you and to cross-examine the other side? Is that the basis?
No, it's just because I think procedurally it would be wrong. You need all your witnesses there. And the board's view is that there are problems regarding the consistency of the advice and the basis of the advice that Nature Scott has issued. They've done it twice, 2024 and 2025, and they differ substantially. Now, they have the last word. The board's not been able to comment on that formally, but my advice to you is that you probably need to hear from them. And my attitude on behalf of the board is we wouldn't want to go to cross-examination, to go that formal, if one of the main players was not represented.
Okay. Mr. Trinick, would you like to come back on that?
Thanks. So I think, first of all, I think an inquiry session is needed here. This is a technical topic. And to get to the bottom of that topic, there needs to be a good, thorough examination of the evidence in an inquiry session. It is quite clear that Nature Scott has withdrawn its objection, does not wish to play a part in the oral session. And I'm afraid one of the penalties of objecting on a technical topic is you may be required to give evidence at a public inquiry. So I'm sorry, we maintain our request for an inquiry session, and it's up to the Salmon Fishery Board what they do about that and who they bring.
Okay, Mr. Youngson.
Okay, to be clear, oh, sorry. To be clear, we don't object at all to participating in an inquiry session. We would welcome that. For your point of view, Mr. Bouillon, the question is what level we participate. So we would have a discussion at any time, but it comes to cross-examination. There's no point, it seems to the board, in having two of at least three parties there. So I'm asking you to consider whether it would be appropriate to proceed on that basis. The board's view would be that it would not be happy about it, but we were very happy to participate in the session of the less rigorous type that you described.
Okay, as some may know, I'm quite content usually to try to tackle even relatively technical matters by a less formal procedure where I can. I have to say, as you said yourself, Mr. Youngson, this is a particularly technical issue, which I would not pretend to have any expertise in, which I think would hamper my ability to get to the bottom of which side of the argument I prefer without the assistance of the more rigorous procedure that a formal inquiry session can deliver. And the last thing I want to do is get to the end of a session and still feel I don't fully understand which side of the argument I prefer. That wouldn't benefit anyone. I understand your point about Nature Scott, but I mean, Mr. G has made their position clear. You would have the opportunity at the inquiry session to explain why you disagree with Nature Scott, or why you question why they've changed their position, or why you think their reliance upon conditions is inappropriate. Nature Scott still has the opportunity, if it wanted to revise its position and to appear at the inquiry. But I wouldn't be minded to try and compel them to attend. Mr. G has made their position clear, which is that they don't object, subject to conditions, and that raises another point, because there may well be a discussion on conditions and what conditions would be adequately worded in order to give the reassurance that parties might want in the event that ministers decided to approve the scheme in terms of protecting salmon and all the other interests. So, come back, Mr. Youngson, if you wish.
The conditions do not relate to the matter that's in contention.
Okay.
The conditions relate to things like water quality and what have you, and the board has no issues with any of that aspect of the proposal.
Yeah, sure. I mean, there are conditions that would relate to micrositing. That's what I was thinking. So nothing can come closer to the river, etc. But I appreciate that. I think my understanding of your position is that wouldn't be sufficient. Even where they are at the moment, without them coming closer, your view is that the turbines are unacceptable in terms of their effects. So I appreciate that wouldn't get you where you want to be. Mr. Trinick.
It might help to introduce inquiry statements leading to inquiry reports here, so that each party, the Southern Fishery Board and the applicant, knows more precisely where we are apart, to help limit the inquiry session to what really needs to be discussed. But I'm afraid we can't back down from a request for an inquiry session on this very technical topic.
Okay, yeah, I understand. Yeah, I have to say, Mr. Youngson, I do agree with Mr. Trinick on this because of the technical nature of it, because it's, to me anyway, it's novel, and I'm very aware that I need to, really get to the bottom of this. I do think formal inquiry session is required. I mean, I'm not trying to suggest that a formal inquiry session is some horrendous ordeal that it takes a huge amount of resources to do. It doesn't necessarily, but it is a more rigorous procedure where those who are better at asking questions than I are able to get to the bottom of the evidence and really just determine how far apart the parties are. As Mr. Trinick says, it may be that some of that process can actually be conducted in writing well in advance, so that there may be matters in where you do agree, and then we can focus down on those matters where you clearly don't agree. I think that's going to be the best way to proceed. I hear what you say about the absence of information, which you've raised before, and the absence of explanation from, as you see it, from Nature Scott as to why their position has changed. But all of that can come out in your submissions in the inquiry. Did you want to come back, Mr. Youngson? You had your hand up and down.
No, I'm inclined to agree with you. Of one worry that will be familiar to Mr. Kelly, but of course it's just a general point. But all of the applications are coming, and this one as well, places a tremendous load on people and on organizations that are not resourced to deal with it.
No.
So it's an easy way for a well-resourced developer to pursue the most rigorous thing that gives them the most chance of getting the outcome that they want. I understand that. But I think under the circumstances, I would have to go back to the board and ask, for example, if they wanted the board to be represented by me as a technical person, and also whether we need someone with a legal background to conduct cross-examination of the other parties. But if we do it, a lot of it, try to get out of the way by writing, maybe it's something you could come back to, because then we'd have a more defined task to deal with in the most rigorous way. But in the meantime, I can't see how that would work. It would be grossly imbalanced in terms of resources, and it would be unbalanced by the representation of only two of the three parties key.
I hear what you're saying. I mean, if it's any reassurance, parties can participate in inquiries, formal inquiry sessions, without legal representation, and quite often do quite successfully in those. So it's not mandatory that you have legal representation. I would run the inquiry in such a way that you were able to benefit fully from that. And I know Mr. Trinick wouldn't be intending to run it in any way that was unfair to you. It's the idea is, I just want to get to the very bottom of the evidence, which at the moment I don't understand, and I'm reliant on you and the applicant's expert to get me to that place, and I will do that in the best possible way that enables everyone to feel comfortable and able to tell me all that they need to say. Mr. Youngson.
Which is to reassure you, the topic is a scientific topic, so it is technical. It isn't actually very difficult, but the two positions have become very confused.
Okay. Well, we'll park that for the moment. As Mr. Trinick suggested, it may well be we can narrow down, to some extent anyway, how far apart you are on the various topics, and we can use that to have a focused inquiry session where hopefully we can get to the bottom of where the differences are and come to a recommendation on this important matter. Actually, before I leave salmon, I had a note that was a question really as to the relocated bridge position, Mr. Youngson. I was unsure as to whether that remained a concern of yours that we needed to include within the scope of the inquiry session, or are you now content on the effects on the bridge?
No, the board has documented that. We're happy with that. That's good.
Good. Okay.
We documented that immediately. Yeah, that was in advance.
That was my recollection, but thank you for confirming it. Excellent. Before I move on to birds, and apologies, this wasn't on the agenda, but it dawned on me yesterday, the effect on Blanket Bog, Wet Heath, and the SAC, and the World Heritage Site for that matter. I'm pretty sure that Nature Scott is now content, subject to mitigation conditions, that there would be no threat to the integrity or qualifying interests or anything else of those designations. I'll ask Mr. G first if that understanding is correct.
I might sit on the fence slightly, sir. I think
Okay.
that understanding is correct. Perhaps I could follow up in writing after the meeting to confirm the position.
Okay. Sorry to spring this on. It was unfair. It only dawned on me yesterday that the reason why I questioned it was more to do with the council's position, because I know the council kind of reserved its position that in the event that Nature Scott was indeed content about effects on the SAC and the World Heritage Site, it might consider whether it was also content. I think it had raised it as one of the two sort of nature-related technical objections where it said maybe, depending on what Nature Scott decides, we might also be content. I don't know if you know, Mr. Finley. Again, I'm springing it unfairly on you too, as to whether you know an answer to that question.
I think I don't. As far as I understand it, our sole concern is the visual effects, and we have no desire to be involved in, no need to be involved in any other matter, save insofar as we can assist you.
Thank you. Okay, Mr. Trinick, is your understanding that, again, I'm springing it on you too, but Nature Scott's was now content, subject to conditions in terms of the SAC and the World Heritage Site?
That's my understanding.
Yeah. Okay.
I can't say any more, but that is my understanding, yes.
No. Yeah, Mr. G.
Those from Nature Scott who are instructing me are on the call, so perhaps someone could drop me an email before the end of the meeting and I can confirm the position to you there. But I understand that your understanding, sir, is correct.
Okay. Yeah, that would be great. Or if anyone wants to chip in, if they can definitively say that is correct, during the course of the meeting, that would be helpful. And apologies for just bringing that up. As I say, it dawned on me in the last minute. My understanding is that Nature Scott is content, subject to conditions, and that the Highland Council was minded to not to push the matter if Nature Scott was content. Ms. Irving, you might have an answer for us.
Yeah. So yeah, your understanding is correct. We're content that subject to conditions on the SEC and World Heritage Site. So we have no outstanding objection on those points.
Excellent. That's very helpful. And apologies to you too for putting you on the spot on that one.
No, I thought it'd be quicker than sending Callum an email going to it.
That's very helpful. Thank you. Mr. Kelly, I'm assuming from the local community's point of view, you don't disagree with that. You're not wishing to raise points on those matters specifically?
The local community has a concern about the effects on the World Heritage Site, and they're slightly disappointed that the Flow Country Partnership is not represented in this inquiry and giving you advice. But we don't have a technical expert. We are likely to address our concerns when the relevant conditions are discussed. And I'm satisfied we can raise the concerns we have during the condition session. So I would not ask for any further process in relation to the World Heritage Site and to accept what everybody else has said to you this morning, sir.
Thank you, Mr. Kelly. That's helpful. Okay, back onto things that actually were on the agenda. Birds. So effects on birds and consequences for the qualifying interests and integrity of the SPA. The rejections from Nature Scott, as we've heard, Highland Council, although I think again that was a conditional objection that depended on Nature Scott's position, RSPB and others. A question for Mr. G. I think the Nature Scott objection is confined to displacement and disturbance effects for short-eared owl, and that for everything else, mitigation via conditions would be sufficient. Just check that that's your understanding.
Yes, that's right.
Okay, good. Now we've heard about the RSPB position in terms of the adequacy of the information, and also its position in respect of being able to attend oral process. I know, Mr. Trinick, you've previously said you think short-eared owl needs to be the subject of an inquiry session. I'll come to you now.
Yes, sir. I just wanted confirmation from Mr. G that we are indeed focused on a single species here, short-eared owl.
Thank you.
Correct. Okay. In that case, yes, we think an inquiry session is needed. As to the other species listed in your bullet point, we've really already dealt with those in the context of RSPB and written submissions.
Indeed, yes. So, Ms. Garland, I appreciate what you've said about your ability to participate in oral process. If there is to be an inquiry session involving the applicant and Nature Scott, is it your intention just to not participate, or if it's limited to just one species, does that make it easier or possible for you to do so?
Currently, we would be limited to just written submissions, but if it is decided that there's an inquiry session, we would consider that. But currently, yeah, we would only be able to commit to written submissions.
Okay.
But I appreciate if it was restricted to one species, yeah, we can consider that. But
okay.
I'm not able to commit, I'm afraid.
No, that's fine. You can give it. I mean, subject to what Mr. G says when I'm just about to ask him, but whatever procedure I decide we need to have, and which I will tell you about in the note of this meeting, then you will have the 14 days to decide. Right, are we opting into that or are we not? So you'll have a bit of time to think about that. Mr. G, my question was really in terms of inquiry session or a less formal hearing session. Mr. Trinick's view is it needs to be inquiry, technical evidence, etc. Are you content with that, or do you want to disagree on that point?
Sir, with respectfully, I just want to disagree on that point. If the scope of the hearing on ornithology is restricted to single species, the dispute between or disagreement between Nature Scott and the applicant seems in my view to be relatively narrow and essentially one of a difference of professional opinion. I would have thought that, of course, recognising it's entirely a matter for you, that could be dealt with at a hearing session, and potentially that's the most efficient and proportionate way to hear that evidence. You can hear from the applicant's witness, you can hear from Nature Scott's witness, and inquire about the kind of narrow differences of opinion between them. I don't understand and whilst I hear Mr. Trinick that further surveying work will be undertaken, I don't understand be a significant difference of fact between or dispute of fact between the two parties.
Mr. Trinick, sorry, Mr. G, carry on.
So apologies. So just to conclude that my position would be that a hearing session would be appropriate to deal with that narrow disputed issue.
Thank you. I am quite tempted by that approach, Mr. Trinick, just because I'm not an ornithologist either. But if we're dealing with simply disturbance and displacement effects on one species, and if I were to approach a hearing session by, as I said before, giving you plenty of notice of the lines of questioning I think I would need to make, to which you can add anything you think I have missed, it does seem it's a more time-efficient process to have a simple roundtable discussion, maybe taking only half a day, and that would be adequate, would it not, to get to the bottom of the short-eared owl? What do you say to that?
I say that I'm waiting for an answer on my WhatsApp group to that very question, I'll let you know when I have it.
Okay.
But I understand the point being made. When I get an answer, I'll communicate.
Thank you. That's fine. Excellent. Right. So I had indicated as a possible matter for oral process the question of biodiversity mitigation enhancement. To be honest,
sorry, sir, can I jump in? I had
Yes,
the
Mr.
electronic hand.
sorry,
up.
I failed to see that.
That's okay.
Go ahead.
Okay, sir. Just to clarify, jumping back on ornithology to the written submissions, I've made clear to my clients that when we give you this list of local observations, we will also give you the months of the year when these species are seen. So we think that would be more helpful rather than just a list of the species. But I will certainly try to do that in response to your minute of the meeting, sir, so that information is in circulation as early as possible. I just wanted to clarify that. Thank you.
Yeah, that'd be very helpful. Thank you. Yeah, so biodiversity mitigation enhancement, putting that down as a potential requirement for oral process was probably predicated on the basis that RSPB would be involved in other oral process sessions, because I think the adequacy of the mitigation enhancement and the potential for it to have unintended adverse consequences for certain bird species was something that they had brought up. If it's the case that RSPB aren't coming anyway to participate in oral process, I would be inclined simply to deal with this by further written submissions. I assume, Ms. Clowney, you wouldn't have any problem with that, given that you don't really want to come anyway to participate orally.
Yeah, we would certainly be happy with written submissions for that.
Ms. Trinick?
I came in with that.
Thank you. Good.
So while I've got the microphone,
Yes.
on the issue of short-eared owl, this is, I think, the first time this species has been debated in an inquiry context, and we still believe that an inquiry session, what is a technical topic, is most appropriate. But so as to give something back to Mr. G, can I suggest that we have FWS to inform you of the precise issue between the parties, and then we can make up our minds, or you can make up your mind on what process needs to follow.
Okay. Yeah, I'm happy with that. I am conscious, the little I know about short-eared owl, I know that the effects of how you quantify the varying distribution over the years and the effects of other wind farms may be affected by the prey availability and things like that. That's the extent of the short-eared owl issue, I understand, because it is, as you say, quite an unusual one, and therefore probably quite an important one. So, okay, we'll do that. What I think I will seek further written submissions to try and narrow down through a series of questions where both parties' respective positions are. We will timetable some form of oral process in, because I think it's unlikely we'll get to a position where I fully understand things from those written submissions, and then I'll come to a judgment as to, depending on how far apart the parties are and how technical the evidence is and how lacking my understanding of that evidence is, I'll then decide whether we need that to be subject to oral process in the form of inquiry or something less formal. Mr. Trinick.
Just a fair warning that I'm getting a very clear instruction that we would want an inquiry session, and it is a view I support. Let's have those written submissions, but at the moment we are of a fairly clear view.
Okay. If you're content with that, Mr. G, we'll try and narrow things down in writing, but and then I'll make a decision as to where we go from there. You content with that?
Yes, content with that. I think we'll participate in that as well.
Thank you, Ms. Cleland.
It was just whether it was just a request for clarification, I suppose, in terms of whether the information on the 2026 breeding survey results, if we would have seen them before the written submissions, further written submissions are requested on this topic.
Yes, that would be helpful. I'm sorry, Mr. Trinick, I can't find on my note. You did tell me when you were hoping those would be available, and I simply can't find it at the moment. How would that fit in?
Early August.
Okay, so
August, at least the results may be available sooner. They'll be released when available, but the report, which reports on the results, won't be available until early August.
Yeah, by which time I'll have needed to come to a decision as to what.
Yes.
Well, what we're doing, probably yes. I mean, it doesn't strike me that if we have a week identified for oral process, that we'll be short of time because it's fairly focused. So I'm just thinking that there's a differential between doing something as a half-day roundtable discussion, and maybe if it required an inquiry session, it might take more than that, but it's not going to take more than a day to talk about one species, I suspect. So I'm just thinking in terms of the timetable and when recognitions and things would need to be in an inquiry documents. Even August might not be. Well, we'll see when the date's going to be, but even August might not be too late. But obviously, the sooner we could have something, because I'll need time to consider, based upon the written submissions, where I think we're going before then. But I'll give it some further thought. But so that's the timeline, Ms. Cloud. It may be not until August. So I'll need to give some thought as to how that fits in with the decision. I think we definitely will need to pencil in an oral session to talk about it. It's just, and if we set aside a day for that to happen, then whichever way it goes, there will be plenty of time. It's just how that feeds into the timetable for the type of document that is produced in advance of the session, which will obviously vary depending on whether it's inquiry or hearing. But it doesn't sound like that's going to be too problematic, to be honest. Good. So, if there's nothing else on either birds or biodiversity, the next matter I had was the question of policy. My intention in that regard is really, I suppose, recent developments in policy. I think we probably all know what NPF4 and onshore wind policy statement and all the other favourites have to say about it, unless someone disagrees. I was intending probably the focus of this was more sort of recent developments, things that people want to tell me that might have changed recently, or the directions of travel and that sort of things. Trinick, did you have any thoughts on policy?
Yes, so it's quite a lively time for emerging policy. I think a half-day hearing session would be appropriate.
Thank you. Mr. Finlay, you're content with that?
Well, our suggestion would be to have an early statement of agreed matters and written submissions, and by all means make provision for a half-day hearing session if you consider it's necessary, but it may not be necessary. But certainly we have, with Mr. Trinick's team, a good track record of agreeing reasonably comprehensive statement of agreed matters. And if there are issues that we can't agree, if there's a short exchange and written exchange, you can then determine whether you need a half-day hearing session. So by all, certainly pencil one in at this stage, but it may not be necessary is all I would say.
Yep, that makes sense. Yeah, we could, I mean, as will become clear when we get to the conditions, it might be it would slot in on a day with that if, as I say, if we need it. I'm content if Mr. Trinick doesn't agree that we'll kind of try to resolve agreement and disagreement on policy in writing, but if there's any outstanding queries that I have, then we will have reserved a half-day slot to talk about those. Mr. Kelly, did you have any? I'd imagine you would probably be intending to participate on policy.
Yes, sir. Thank you. I'm not a great lover of statements of agreed matters, which tend to be developed simply between the applicants and the council, leaving third parties out in the cold. My preference would be to have the normal hearing statement and then a short hearing session. I think a half a day would be more than adequate. I think if you have a statement of agreed matters agreed too early, then things could happen between now and the end of October, beginning of November, which might raise policy issues. So my preference is to side with Mr. Trinick and go straight for the hearing procedure.
Yeah, I can see your point. I mean, we could, rather than calling it a statement of agreed matters, perhaps we could agree, we'll set something in the diary for a hearing session, and I could accept hearing statements, but in the event that I was content that I understood the respective positions, I would then decide not to have the hearing. If I thought it wasn't going to give us anything, although we had reserved a slot for it, if I either understood that you all agree on things, which I suspect is not going to happen, or if I understood why you disagree, then perhaps we could then just say, okay, we don't need the hearing session. It won't serve any purpose, but at least we've got the option. If as I suspect is quite likely, there are certain matters where there is disagreement rather, and I'm not entirely confident that I understand, fully where the disagreement is. Mr. Kelly.
I think that's sir.
Okay. Are the people content with that? So rather than calling it a statement of agreement, it's an opportunity for parties to submit their position on policy in writing, and then it will become apparent to me anyway where there is disagreement. I mean, I wonder whether I don't want to make more work for people, but whether there could be an opportunity for a rebuttal of those written statements. So you submit your position on policy, you have the opportunity to rebut the opposing view in writing, and then on the basis of that, I will decide whether there needs to be. Mr. Finlay.
I was just going to suggest that, I mean, I hear what Mr. Kelly says, and I have some sympathy with his views for the party he represents, but there still may be sense in the applicant and the council seeking to agree a statement of agreed matters. It will then allow us to concentrate on the issues that are in dispute between us, and Mr. Kelly can then react to whatever he doesn't like in the statement of agreed matters. So I still think it would be a useful step for you. I don't think it will disadvantage Mr. Kelly, and I'm quite happy with the other procedures which follow. But it would then save the council and the applicant setting out at length matters they're agreed on, and then they can deal with areas of disagreement proportionately.
Okay, yeah. Mr. Trinick.
I find myself unusually completely agnostic about this. I'm perfectly happy with the statement of agreed matters as between the applicant and the council. I'm equally happy with Mr. Kelly's hearing statement idea. I think ultimately you will benefit from short oral process. I can think of 2 or 3 issues I won't articulate where I think you would benefit from oral process. So whether you go via a statement of agreed matters or straight to hearing statement, I don't mind.
Okay, yeah. Just thinking on the feet, I think I'm quite attracted by actually Mr. Finlay's approach. I don't want to put people to work that ultimately, as he says, is not necessary. If it is the position that the council and applicant at least are in agreement on a lot of matters, then if that was set out in a statement of agreed matters, and then Mr. Kelly was given, and any other party were given the opportunity to provide their comments on that, that might be a more efficient way of doing that than everyone preparing a hearing statement. And then at that point, I could then decide, as I suspect will probably be required, whether we have a short session to talk about those matters that I'm still unsure about, or where there is clearly a difference of opinion. Would you be content with that, Mr. Kelly?
Yes, sir. Happy to proceed.
Okay, thanks. Nothing else from anyone else on the policy question? No. Okay, good. So community hearing session, I mentioned earlier on what they are and why they're quite often quite popular with members of the local community, because it is less formal, less onerous in terms of the administrative procedure. Unless anyone tells me that it's a terrible idea, I was minded to arrange one for the inquiry week, one evening during that week, usually towards the end, when parties will have the chance to come and tell me anything they're concerned about. And what usually happens is the applicant is usually there just in case they're able to provide an answer to some factual question or something. But it's not generally, how I've run them anyway, the case that the applicant is there to question or to disagree with members of the public. It's their opportunity to tell me what they think, primarily. So unless anyone thinks that's a terrible idea, I was proposing to have something like that for the community. Mr. Kelly, did you want to say anything on that?
Yes, sir. That'd be very much welcome. I would look to help you, sir, by ensuring that short statements were provided by parties in advance. I don't think there'll be vast numbers. There are a couple of people who are very reticent just now about speaking in public, even though I've told them they wouldn't be questioned by other than yourself. they are wondering if they might have their presentation recorded on a video and show the video on the night, but they would be present. I realise that creates technical issues, sir, and I'm still hopeful of persuading them to speak in person. But I would certainly look to help you, sir, by coordinating the evening session. And it's probably the right time to mention the other aspect from the community is that they would be looking for an accompanied site visit to a few of the local houses, to my client, Miss Haltner Dale House, which is being restored just now, and to Westerdale. My estimate is that you would only need an hour and a quarter for this, and we could organise the logistics near the time, but certainly we would be requesting a short accompanied site visit.
That's fine. Yeah, thank you. And thanks for your offer, Mr. Kelly. That would be helpful if somebody could coordinate the community. It makes things run more efficiently. On the question of video, pre-recorded video participation, I don't think I've done that before, but I'm not saying it's impossible. I appreciate fully why, it's quite nerve-wracking to speak in public, and I can understand entirely why people might not be comfortable with that. If you can do your best to reassure people, I know you've been to plenty of these, generally they're not too horrendous, and it's something I think people actually get some benefit out of having done it. But I can speak to our people in our office about how technically it could work. If we've got a TV screen, it may well be quite straightforward to do that. Mr. Trinning, did you have any views either on your role in that session, or if you had any objections to somebody pre-recording what they want to say?
No objections to pre-recording. If it can be done, that's fine. And our role in the session is to be there, say nothing until you ask us to say something. No objections to anybody.
Excellent, thank you. Nothing else on community hearing sessions? No. Okay, getting through it quite well. Item 6, indicative timeline. So I think originally we were talking November, then perhaps January 27, but then there was a suggestion of week commencing 26th of October, I think. I don't know what progress there has been in terms of agreeing whether that's possible or not. I'll start with you, Mr. Trinick.
I understand, sir, that 26th of October may be wrong, but I think it's been agreed between all parties as available and suitable.
Anyone disagree with that? No, good. That's good. And it's in our diary as well. So in terms of duration, I haven't been totting up, which I should have been, but I mean we're not at risk of running out of time in a week, certainly, as far as I could see. So in terms of when we start, are we saying start on that Tuesday of that week rather than the Monday to allow travel time other than at the weekend? And then I guess, do we need to book time until the Friday, or do you think Tuesday, Wednesday, Thursday would suffice? I'll start with you, Mr. Trinick.
I would say I don't mind starting at Edinburgh on Monday, but Thursday is another matter. I think if we can start Tuesday and allow until Friday, that would give us ample time.
Finley, any disagreement with that? Oh, anyone else? Mr. Kelly, no. You can turn Tuesday to Friday.
That's fine, sir. Can I just also, is this the point in time to raise the issue of the venue?
Yes, that would be helpful. Yeah.
Our suggestion is the Ross Institute in Falkirk. It's very local to the application site. It's been used before for public inquiries. There's hotel accommodation in the village at the Ulster Arms, which I think most of us know. And there's also a shop that sells sandwiches and coffee, and it would be a suitable venue for the local people to attend. So obviously the case officer will need to check up on the Wi-Fi, etc., etc. But we have used the Ross Institute in Falkirk before, and it's my suggestion. The only other alternative generally is the way in at the Thurslow Scrapsor Road junction. It's not my favourite place, apparently. So the preference of the local people is for the Ross Institute at Falkirk. Thank you, sir.
Mr. Trinick.
I know the Ross Institute pretty well. I've been there far too often. It's okay, but we are talking about the 26th of October, and I'd say it might be best and safer to opt for, I can't remember the name of the building. It's a large community centre or hall in Thurso, that we used for the Limekiln inquiry. That seemed to work very well indeed. It has all the usual disabled access, etc.
Okay. Yeah, I take your point about weather, etc. I'm conscious I'd like it to be as local to the site as possible. Well, I'll put those two suggestions to the case officer, and we'll see where we get to. That's helpful. Thank you. Very quickly on document management, I'm sure you all know far better than I that, or many of you anyway, will do. We've revised how we handle documents for inquiries. The idea being to avoid duplication, avoid documents coming in that nobody actually refers to in the inquiry itself, or to narrow down the scope of documents that are put in so that only extracts that are to be referred to are put in rather than the entire document. It saves everyone reading things that turn out not to be relevant in the end. So the procedure is an electronic document list, foundation document, and then supporting document lists will be prepared. The list will be started by the case officer. So she will populate it with hyperlinks to all the plans and other documents that comprise the application as they're stored on our system. And then the applicant will take control of updating that list to include any other of our library documents that they wish to refer to, and other parties can contribute to that as well. And then the supporting documents part of the list is sort of case-specific documents the parties want to refer to, or extracts thereof, preferably. And the idea of it is that the list is circulated around, it's populated in advance of the inquiry. The applicant's responsible for managing that process, and then the list is finalised, and that final list is then a useful document with hyperlinks to all of the relevant things that we'll be talking about. So everyone's looking at the right thing. Everyone who's simply click on an electronic link, and we're all dealing with the same PDF and the same page numbering and all of that sort of thing. It seems to work really well in my experience, but it's just it's a bit more onerous for the applicant to administer, but I'm sure they're not complaining about that, and it does seem to help the procedure go. So there's a guidance note. I think it's guidance note 29, which I think I said provided a link for, which hopefully explains a bit more about how it works. But if there's any queries on it, the case officer is usually very good at helping you out with it. And I appreciate it, as I said before, the administrative burden of the sort of more formal processes can be seen quite onerous for those who don't do this for a living. But the idea of this document management procedure is it's designed to be as painless as possible for those who don't do this, full time. In fact, the purpose of it is to avoid having massive amounts of documents in various different places that parties need to find and read, and it's designed to improve and reduce the amount of time that's taken. So hopefully that will be people's experience. Really, finally, the person to contact if you've got any queries is Morven Campbell in our office. I'll put her details on the agenda. She will be able to help you out with any questions as to procedure and what you need to do and timescales, etc. As I said, I will issue a note to this meeting next week, which will set out the various things that we've discussed today. It will have a timetable for when various things are expected to come in and when things are required to be submitted by. The key deadline really is 14 days from that date is when you need to make your mind up as to which sessions or which requests for further information you will be participating in, so you don't miss the boat. And as I said before, that note will go out not just to everyone who's here today, but to anyone who has previously opted into the case. So just because you haven't come today doesn't mean you've missed the boat by any means. I think that was all I needed to talk about today. Was there anything else that anyone wanted to raise? Nope. Okay. Well, thank you all. As I say, it'll take me a couple of days to get the note out, but hopefully that will explain to everyone's satisfaction what we're doing when we're doing it. But if there are any queries, do come back to the case officer and I'll try and clarify if there's anything I've missed or anything that's not clear. But I think that's been very helpful to me. We've got a date fixed. We've got agreement pretty much on where we're going in terms of procedure. Yeah, I'm happy. Thank you all very much. It's been very helpful, and I will see you in October. Thank you very much.
Thank you.